Now, in last class, we had started the chapter contract law, and to form a contract, there were some essential elements. The first one was an agreement in which there was an offer by one party, and the other party have accepted that offer. And then there should be some consideration, right? There should be some consideration to a contract. And the next element of the contract is intentions to create legal relations. That when the parties were forming, or they were going to form an agreement, there was an intentions that they are going to be bound legally. So this is necessary, that in order to create a contract, both parties must intend that they are forming a legal contract. Like for example, I gave you an example in the last class as well, that let's say for example there's a younger brother, he asks his elder brother that I want your car for a ride, and here his elder brother says that take this car, this car is all yours. Now, his wordings, this car is all yours, it does not indicate that he is, entering into a legal relation, and he's actually transferring his car to his younger brother, right? There was no intention. So, similarly, in order to form a contract, there must be an intention to enter into the legal relations, and you have to prove that. Now the thing is, first the court will look at the contract. If from the contract it is clear that there was an intention, that that contract will be considered as valid contract. But if it is not clear from the contract, then the court or law presumes intention by type of agreement. If the court is not able to judge whether there was an intention by just looking at the contract, then they look at some assumptions, and they assume by looking at the nature of the agreement, type of the agreement. In case of domestic or social arrangement, it is presumed that there is no intention to be legally bound. Usually, normally, if the agreement or contract, is done by someone who is in, like for example, who is in a relation, like for example, a husband or wife, father or son, family and friends. If the contract is done amongst the family members or friends, then these are known as domestic or social agreements. In in such cases, court normally assumes that there was no intentions to create legal relation. But if this presumption can be refuted, reversed, then the intention can be considered that there was some intention. Like for example, if a husband and wife, they are living happily, then the agreement between them will be considered as that it was just general agreement. There was no intention to be bound by legal relation. So the court will assume that the law will assume that there was no intention. Like there's a case in your book in which the defendant, who was a husband, he was going abroad in some other country. He promised his wife that he will pay 30 pound per month to his wife, and against the consideration that his wife, she will support herself. She will support herself. She will do the maintenance of house herself. So that was a promise. So husband made a promise to his wife that he will send 30 pounds per month to his wife, against which the wife, she should do the maintenance of the house herself, okay, without calling him. So the wife, basically, when the husband went abroad, he didn't pay his wife the amount, and the wife sued him for that amount. When that case was brought forward to the court said that there was no legal binding contract. Why? Because it was a domestic agreement, and husband and wife, they were living happily. There was no quarrel situation. They were not fighting. So it was just a domestic agreement. And if there's a domestic agreement, it is assumed that there is no intention to be legal relation, but no intention to be bound in legal relation. But in some case, this assumption can be reversed, refuted. Like for example, in separation situation and divorce situation. Like for example, if the husband and wife, they are not living happily, there is fight amongst them, and they are going to be separate soon, or they are going to get divorced soon, or even if they are divorced, then in that case, obviously we will assume that the agreement that they did, there might be some intention to create legal relation, right? Because when they are fighting, the agreement is not considered as domestic agreement. It is a domestic agreement, but because they are fighting, they are in a quarrel situation, they are about to get divorced, they are about to get separate, then the assumption that in the domestic agreements, there is no intention to be legally bound, we refute it, we reverse it, and we say that there was an intention in this case. Like for example, there's a case in your book, Married versus Married, in which a husband who was separated from his wife, he made an agreement with his wife that the wife, if she pays the outstanding mortgage debt, okay, outstanding mortgage debt of the house, husband will transfer the house to his wife. So basically, the house was in the joint ownership of husband and wife. Husband did an agreement with the wife that if the wife will pay the mortgage payments of the house, remaining mortgage payments, I will transfer the house on her name. But when wife did pay the mortgage amount, the husband didn't transfer. Then the wife sued the husband, and when the case was brought forward to the court said that in this situation, they were separated, right? They were separated, and this agreement we will assume that there was an intention to be bound in legal relations, right? Because they were separate, they were about to be separate, or they were separate. So in such case, the normal assumption that there was no intention to be legally to be bound in a contract legally, it is reputed, it is reversed. Okay, in property matters as well, when there's a matter between property, you have to understand the nature that someone is talking about some agreement regarding the property. Then in that case, whether they are in domestic, whether they are relatives, whether they are friends, then if there's a property matter, then the court will look at the contract clearly, because in such cases, it does not matter whether there is a family relation. There must be, or there can be, there can be an intention to be legally bound. So the court generally look at the nature of the agreement and then decides. But the normal rule is that if in case of domestic or social agreements, we assume that there was no intention. But but this assumption can be reversed as well, like in the divorce situation, in a separate situation, in the property matters, in a business situation. Business situation means that someone who is, you have done some financial arrangement with someone in the family. Like for example, you purchased, let's say, uh, you can say, okay, you invested in something. Okay, like for example, there were three brothers, and they made an investment in something. They made an investment in some, something, and they purchased, like say, they purchased a lottery ticket. For example, there were three brothers. They purchased a lottery ticket, and the cost of the lottery ticket is $90, and each brother paid $30, $30, and they did an agreement that it will be shared amongst them equally if they won the lottery. And when they will won the lottery, obviously, now the thing is, the lottery ticket is purchased on the name of only one person, right? But the payment is made by all three brothers. So the ticket was purchased by one. The ticket was purchased on the name of one brother, but the payment, other two also made an equal contribution in the payment of the lottery ticket. But when that lottery will be received, the brother whose name the ticket was, he cannot claim that this is all mine. Okay, this is all mine. Why? And he can say that this is a domestic agreement. We are brothers. So there is no intention to be legally bound. And if there is no intention, there is no agreement. There is no contract. And if there is no contract, I am not bound to pay them their share, right? But here the court will say that this presumption is rebuted, is reversed. Why? Because this was a financial arrangement. This was a kind of like a business situation where you paid equal amount to get that lottery ticket. So the winning amount, it should be also shared amongst all the brothers. Okay. So in this way, you have to look at the nature of the agreement. In case of commercial agreements, it is assumed that there is intention to be legally bound unless proven otherwise. This is a very common thing. When there is a commercial agreement, then in commercial agreement, in most of the cases, in majority of the cases, there is a presumption that there is an intention to be legally bound, right? Why? Because it is a commercial situation. It is a business situation. So in business agreements, business situation, there is always, in most of the cases, there is an assumption that you have an intention to be legally bound, so the contracts are considered valid. But you can, if you have to prove this otherwise, if you have to prove this otherwise, you have to give a strong evidence. Why? Because in the business situation, it is like 95% there is an intention to be legally bound, right? A letter of a comfort has no legal effect. Now letter of comfort is also related to a commercial agreement. Now what is a letter of comfort? Like for example, there is a parent company who is holding a subsidiary company. A company, a parent company, this company is also holding another company as that is known as subsidiary company. Now this subsidiary company is going to do some agreement with this third party, okay, regarding anything. Now this third party contacted the parent company and asked them that we are going to start a business with a subsidiary company, S company or subsidiary company, and please let us know whether that S company have enough resources available that they can do business with us, or they can fulfill our obligations, or they can fulfill the agreement that we are going to make with them. Then the parent company against that can send a letter of comfort to the third party. Now letter of comfort, in letter of comfort, they will just they will just tell, they will just let the third party know that don't worry about that, you can do the trading with the subsidiary company. They have the resources available, they will fulfill your agreements. So the parent company is giving assurance in form of letter of comfort. Now, let's say in the future, the subsidiary company is not being able to meet the agreement with the third party. The third party cannot sue the parent company by saying that, this was a letter of comfort uh, that you transferred us, that you sent us, and you assured us that, the contract will be, the subsidiary company will do the contract with us, will do the agreement with us. You gave us an assurance, but the letter of comfort has no legal effect. So the third party cannot sue the parent company. Okay. Privity of a contract. Now, what does the privity of a contract means? Privity of contract is only parties to the contract acquires rights and obligations under and can sue and be sued on it. Privity of a contract is like a privacy of a contract. Okay. Privity of a contract means, if, like, say for example, if I have done with a contract with someone else, like Mr. A has done the contract with Mr. B, then only Mr. A and Mr. B have the rights and obligations under the contract. They are the ones who need to perform the contract, and they are the only ones who can sue each other. No third party involvement will be there. So that is known as privity of the contract. That only parties to the contract acquire rights and obligations, which means that, they are the ones, who have to fulfill the rights and who have to perform the obligations under the contract, and they are the only ones who can sue each other. That is known as privity of the contract. But there are some exceptions to this rule, in which, the two parties that are forming the contract, it's not necessary that they are the only one who can sue each other. There can be a third party as well who can enforce the contract, who will become part of the privity of the contract. Now, what are those exceptions? Right of the Third Party Act 1999 allows a person who is not a party to the contract to enforce if contract was for his benefit and he was expressly identified by name or description. Like, for example, if Mr. A and Mr. B did a contract, and contract was for the benefit of someone else, like for the benefit of Mr. C, and Mr. C was also mentioned in that contract, then Mr. C is also has now privity of a contract. He also comes under the privity of a contract, and he can also, sue the one party under the contract. Okay, like for example, there was a father who did a contract with insurance company. Now, father did a contract with the insurance company, and the insurance policy was for his son. Now, the contract is between father and insurance company, right? But the contract was for the son, and he was also identified there. So let's say in the future, if father expires, father dies, and insurance company, they are not paying the amount to the son, and they will say that, you are not under the privity of the contract. Contract was done between company and your father, and your father is no more, so you cannot sue us. But that son can sue. Why? Because the contract was done for his benefit, and he was expressly identified by name or description in that contract. Okay. If there is a collateral contract between one of the parties and the third parties regarding the same subject matter, one party and the third party did the contract, then in that case, we will say that, the third party has come under the privity of the contract as well. Now, let's understand this point by a case study here. Okay, this is a case study. The claimant owned a pier and wanted it repainting. Pier, you can consider it as a pipe, basically. The claimant owned a pier and they want it to repaint. They contacted Detail, a paint manufacturer, to inquire about the qualities of the paint, and were told it lasted 7 to 10 years. So I will explain this case in easier word to you. Let's say, for example, there was Mr. A who wants to get his pier paint. Okay, let's say pipe painted. Mr. A wanted to get his pipe painted. So Mr. A contacted a paint manufacturer. The name of the paint manufacturer was Detail. The name of the company, Detail Products. Okay. They contacted them, and they inquired about the paint. And the Detail told them that, you can use our paint. Our paint is very good. It will last for 7 to 10 years. Okay. 7 to 10 years. They assured Mr. A that this will last from 7 to 10 years. Our paint is a good quality. So Mr. A, when obviously Mr. A then employed contractors. Contractors were responsible for painting the pipe. Okay, and Mr. A specifically mentioned the contractors. Mr. A specifically mentioned the contractors that use this paint. Mr. A specifically mentioned the contractors that use the paint of Detail. Okay, the contractors completed the painting, but the paint began to flake after only 3 months. The claimant sued Detail, who argued that there was no contract between them. So Mr. A asked the contractors to purchase the paint from the detail, and when the contractors purchased the paint from the detail, obviously the contractors purchased the paint, so they did a contract, right? The agreement was between contractor and detail. But when the contractor used that paint for painting the pipe, the paint began to flake away. The paint go away, flake away. So Mr. A sued detail, but the detail said that you are not under the privity of the contract. You cannot sue us. But here Mr. A could sue. Why? Because the contract, uh, there was a collateral contract between Mr. A and the third party regarding same subject matter. In this case, basically, uh, the third party is Mr. A, right? The contract was between the uh, contractors and the paint manufacturers. Mr. A is a third party. But Mr. A inquired about the paint from the paint manufacturers and they assured them. So there was an oral agreement, right? There was an oral contract regarding the same subject matter. So Mr. A also comes under the privity of the contract and they can sue the paint manufacturers as well. Okay. In case of agency law, contract is made by agent, whereas liability is of principal. We will talk about this in agency law as well. That principal, the agent, they do the contract on behalf of the principal. Okay, the agents, they do the contract on behalf of the principal. So the contract is between principal and the third party, but agents are also involved there. So they comes under the privity of the contract as well. Okay. In land law, restrictive covenants runs with the land to which they relate. For example, future owners will be subject to restriction. Now, in case of land law, for some lands, there is some restrictive covenant. Restrictive covenant means there's a clause in the contract regarding the land, and every owner of that land have to follow that specific agreement, have to follow that specific clause. Whoever the owner is. Okay, so the like in this case, the owner of the several pieces of the land sold a plot to another party, making a covenant to keep particular area uncovered with buildings. Okay, so there was an owner of the land who sold his land to someone else. So let's say there was Mr. A. Mr. A sold the land to, let's say, Mr. B. And in the when he sold the land to the Mr. B, he in the contract, there was a covenant. Covenant means there was a clause mentioned in which there was a clause in which he mentioned that the plot that I am selling you, this specific area, you should not, do the construction in this specific area because it is reserved for parks. Like for example, okay, this is reserved for parks or the pleasure ground. Okay, so that was the clause that was mentioned in the contract, that I am selling you my plot, but this portion of the plot you cannot construct some building here. Why? Because it is for the parks or or the pleasure ground for the children. Now, over the following years, the land was sold several times. Mr. B sold the land to Mr. C, Mr. C sold to D, and Mr. D sold to E. Okay, so this land was, the Mr. B sold the land to C, C to D, and D to E. But the covenant keeps on remaining with the land. Okay, that is in the land law. If there is a restrictive covenant regarding a land, it will keep on. You have to follow. It is compulsory to follow that clause, whoever the owner of the land is. Okay. Now, what happened was that there was a certain person, Mr. E, let's say, he constructed the building. He started doing the construction in the building on that specific portion where it was not allowed to do so. So Mr. A sued E. Now, what happened was E said that, I did the contract with D. D sold me the land. So the contract was between D and E. You cannot sue me. But here, because of the land law, restrictive covenants, it is compulsory to follow. So anyone, so the one person who had put up that covenant, he can sue anyone. Okay, anyone who is the owner of the plot. So the court gave an injunction means stay order, and prevented Mr. E construct a building on that certain portion. Why? Because the restrictive covenant was put in regard of this plot. Okay, so the point that you need to understand is that the contract was between D and E, but Mr. A can also sue E. Why? Because of the restrictive covenant that is put up. Anyone who was the owner of the land, he can sue the other person, right? To enforce the covenant. An executor can enforce contracts made by the deceased for whom is acting. Executor is basically a person, executor or administrator. Like say, for example, if some person is on the death of a person, the executor is responsible for, selling off his, let's say, distributing his assets or distributing his assets among, his sons and his family and friends. So he's responsible for dealing the legal affairs of a deceased person. He is known as executor. Now, if let's say the contract was made by the person who is now dead, he made a contract with someone. Now, after his death, the executor is responsible for those contracts. So he comes under the privity of contract as well. Similarly, trust law allows beneficiary to enforce a trust. Let's say, for example, you give your property to someone else and trusted him with that property. And now the trustee is also responsible for doing the contracts, or allow he also comes under the he also comes under the privity of the contract. Okay, like for example, if a person has appointed some trustee, okay, and the trustee is responsible for dealing his affairs. Now the trustee also is responsible for the contracts of that person as well. Okay, so he comes under the privity of the contract as well. And obviously we have talked about the insurance law as well, that if the third party insurance law allows third party to take benefit of the contract of insurance. Like for example, the contract is between the father and insurance company, and the insurance is of son. Then son also comes under the privity of the contract, so he will right also, and he can sue and be sued upon, according to the contract. So that is the privity of the contract. The general rule is only the parties to the contract have rights and obligations under the contract, and they are the only one who can sue each other. But there are some exceptions as well. Now there's a case here. Bestwick versus Bestwick. A coal merchant sold his business to his nephew in return for pension during the lifetime and the payment of the smaller pension to his widow on his death. After the uncle died, the nephew stopped paying the widow. She sued the nephew in her own personal capacity and in her capacity as administrator of her husband's estate. Okay, so basically, uncle sold his business to the nephew, and against that, he asked the nephew to pay me the pension in his lifetime, and after his death, uncle asked the nephew to pay the pension to his wife. Now, what happened was that the nephew was paying the pension to the uncle, but when the uncle died, he didn't pay any pension to the wife of the uncle, who was widow. So the wife sued the nephew, and she was successful, and she got the compensation, and the nephew was asked by the court to pay the amount of of the pension to the widow. Okay, in the administrator of the her husband's state. Administrator basically is like kind of executor. Okay, administrator, because administrator means that she is responsible for affairs of her husband after his death. Okay. Now the next topic is statement of the contracts. Now when the contract is made, when contract is made or when agreement is about to be made, it is under the negotiation situation. There are some things that are mentioned by both parties. Okay, there are some statements that are mentioned by both parties. Now that those statements that are mentioned during the negotiation period leading to the contract, they are classified either as a term or as representation. So statements that the parties to the contract are making while in the negotiation states, leading to the contract, they are classified as either term or they are classified as representation. Now what are the terms and what are the representation? The terms is an obligation. Obligation means the thing that you need to perform in a contract. Major clause of the contract that are usually mentioned in the contract. So let's say uh, the the express things that are basically the terms are basically the clause of the contract that are part of the contract. Terms are the clause of the contract that are usually part of the contract. Okay, usually part of the contract. While representation is something that is said by offerer to induce offering into the contract. So basically, there are two things. Like we are under the negotiation stages, and we are going to make an agreement, and the one party to induce to motivate other party to get into the contract said something, said something, and that was lie. Okay, they said something and that was lie. Then it means that he has done misrepresentation. So representation is basically all those things that is said by one party to another party to induce him, to motivate him to get into the contract. Okay, and that and the clauses basically that they agreed, they are known as terms. Okay, so representations are all those things that one party has said to other party to induce him, to motivate him to get into the contract. Those are the representations, and the terms are those clauses that are part of the contract. The terms are those clauses that becomes the part of the contract. So the clauses that become the part of the contract, that are major one. Major one means important one, a reason for the contract. That are the obligations that you need to perform. Those are terms. which have significance. Representations are those things that you said to induce someone to get into the contract. Okay. Now, if someone will breach the term, if someone will breach the term, then the contract can be considered as terminated. But if someone has misrepresented me, that you induced me to get into the contract. When I enter the contract, you lied about that thing. You lied about that thing. So it means you have done misrepresentation. So if representation becomes term of the contract, innocent party has a remedy for breach of the term as well as misrepresentation. Okay. If, let's say, the term the term is basically the major clause that is the part of the contract. The term is a major clause that is part of the contract. Okay. Now, if that term and representation is basically the things that uh, one party has said to the other party to get him into the contract. Like, for example, he said that, if you entered into the contract, I will pay you this service fee. Let's say, for example, I will pay you this thing, I will do this and I will do that. And now when the contract is finally done, and that representation has become the part of the contract, the things that he said to induce the other person to get into the contract, those things are now terms of the contract. Then the innocent party can sue the person for the breach of the term and misrepresentation as well. So he can get damages for the both situations. But if only representation, if only he has done if only he misrepresented, then in that case the minor compensation is provided. Okay. Now what are the sources of the terms? What are the sources of the terms? Terms can be expressed or terms can be implied. The one thing that you need to be aware of, that when both parties, let's say a common man, when they are doing the contract, they are they are not lawyers, right? They don't have that legal knowledge, so they do an agreement as per their own knowledge. But sometimes the agreement is not completed. In that case, there are some terms that need to be implied into that contract. Implied means that we assume that those terms are also part of the contract. Now, the terms can be either expressed or they can be either implied. Now, what are the express terms? Terms that are agreed between parties and are part of the contract. Two parties have done the contract and they have agreed specific terms. Those terms are known as express terms, which are expressly mentioned, specified, agreed between both parties. Those are known as express terms. They must be clear to be enforceable. Those terms need to be clear if you want to enforce them. Okay. You have to precisely, you have to clearly mention those terms in an agreement or in a contract. Okay. So those are known as express terms. Implied terms are those terms which are not part of the contract, but we assume that they are part of the contract. Like, for example, I will give an example that let's say I did a contract. For example, an employer and employee did a contract. An employer did a contract with employee. They agreed with the different terms, but they forgot to agree on the holiday terms. They forgot to agree about the holidays, that how many holidays should be there. Now, what will you do? Like, for example, the employer can say that you will work whole year because we didn't agree about anything regarding the holidays, right? But in that case, we will assume that the term will imply from the statute or by custom or by code. Statute means by law. Let's say, for example, the law states that there should be at least 4 weeks holiday in the law states that there should be at least 4 weeks holiday in a year. So we will assume that that the holidays will be 4 weeks per year. So we will assume this term into the contract. Why? Because it is implied by statute. So this is how the things work basically. Okay. Like, if you are not aware, or if you, let's say, forgot to mention some terms into the contract, then we will imply those terms from either statute, from either custom, or from either court. Okay. So this is what you need to be aware of. Okay. Now, by statute terms implied by statute basically means the parliamentary law, right? The terms implied by law. Like, for example, sales. There are different laws regarding their different things. Sales of good act, sales of service act, employment law. I gave an example of the employment law that you forgot to agree about the holidays. Let's say you forgot to agree about the pay, what pay should be, right? What sick pay should be, how many sick holidays should be. So you know whether they are not mentioned in the contract or not, but because the statute has specified them, so you can imply those terms into the contract. Okay, the terms will be considered as part of the contract. Why? Because they are implied from the statute, implied from the law. Similarly, there is sales of good act, sales of services act, which tells us about the situations in the case when you are, selling something. Like for example, uh, if someone is selling some goods to other person, those goods should be not be, faulty. The goods should not be faulty. He should sell what he should. Like for example, I want to purchase a product and I got a sample from the supplier, but when I ordered the goods, he sent me some other products. Now, whether this was agree in the contract or not, that, if you send me the faulty goods, you will refund me. Okay. Now, whether this was agree or not, still this is implied from the Sales of the Goods Act, right? It is implied from the statute that the goods should not be faulty. The goods should be one that we ordered. Similarly, for the service should match up with what we agreed, right? And the service should be performed with the honest intent, with the reasonable care and skill, right? They are just implied from the statute. Okay. Then implied from the custom. Custom means what is the customary, what is usual in the practice in that situation, in that area. We will assume that those terms will be implied into the contract. Okay. And the last one is implied by code. Now, how is this work? Let's say, for example, there is an agreement done between two parties, and now they have done an agreement. Now, there are some terms that are unclear in an agreement. So the court will take help from the statute first. The court will see that, whether there are any terms that we could imply in the contract to make the contract, workable. So we will look at the statute, and if there's any terms in the statute, we will consider that, those terms are the part of the contract. Like for example, I gave you an example. Employer hires an employee, and they agreed about many different things, but they forgot to agree about the holidays in their agreement. Now the court will, when now what will judge do? Judge will basically look onto the statute. He will go to the employment law. He will go to the employment act, in which it will be mentioned, in which it is mentioned that there are at least 4 days, there are at least 4 weeks holidays a year. So they will imply this term into the contract that, okay, you didn't agree about anything expressed in the contract, but this term is implied that you are entitled to get 4 weeks annual holidays, paid leaves, and you are entitled to get at least one holiday 1 week. Okay. So you can imply that term by statute. Similarly, you can imply that term by custom. And let's say if there's no statute available regarding that case, and there's no custom available, then court will themselves imply the term. And how? From the past cases. They will look in the past that, whether there was any case in which this scenario happens. So from those cases, they can drive a term, and they can put that term into the contract to make the contract workable. Give business efficiency means to making a contract operational, making a contract workable. Okay. The business efficiency is basically in which court, they themselves imply a certain terms which is not agreed, but they assume that this is the part of the contract. Why? So that contract becomes operational. Like for example, I will just give you a basic example, you will get this point clear. Let's say you contacted with a painter. Okay, you did an agreement, you did a contract with a painter, and you asked the painter to paint your house. Now the painter, you did an agreement, everything was agreement. Now the painter, when he came to the house, he started painting on the wall. He didn't scrapped, he didn't remove the previous paint. He started doing the paint on the already painted wall, on the wall. When you do a painting, first you have to scrap, you have to remove the previous paint, right? And then you put up the new paint. But that person, the painter, he did not do that. And obviously, you ask him that why are you doing this? First, you have to remove, you have to scrap the previous paint from the wall. He will say that, where it was mentioned. This is not mentioned in our contract. This is not mentioned in our agreement. In our agreement is only mentioned that I will paint your wall. Now, this is where the court will interfere and will say that, well, that is obvious. This is obvious. Now, the thing is, when they will quarrel, when they will fight, the contract is very difficult to perform, right? When there will be a fight amongst you and the painter. So now the court will interfere, and they will say that, this is an obvious thing, that the court will say to the painter, when you want to do the painting, first you have to scrap, remove the previous paint from the wall, clean the wall, and then put up the new paint. So court will imply this term to give business efficiency. Efficiency means to make the contract operational, workable. Court will say that, whether it is agreed between you or not in an agreement, that is implied. Okay, that is implied. So this is how the things work. Okay. If any express term is vague, the court may disregard that term. If the express term mentioned in the agreement is unclear, then court can cancel that term as well. If some essential term is missing in agreement, then court implies the term. However, if implied term is not solving the problem, contract is held void. For example, undecided installments. A very good example here. That let's say, for example, two parties did a contract. Okay. For example, a person purchased, let's say, some goods from me. Okay, and we agreed that he will pay me installments. Okay, but we did not agree about installment amounts and installment duration. Okay, we did a contract, we did an agreement in which I sold some goods to the, let's say, other person, and we didn't decide it that, the only agreement that we make is that, I will sell the goods and he will pay me the installments. We didn't decide the installment duration, or let's say we didn't decide the installment amounts. Now what to do? Now there is no express term regarding that, right? The court will see the statute. Now, when they will go to the statute, obviously, when the goods are sold, there are different durations, there are different installment amounts. So, what to put in that case? We don't know that, whether there should 2 years installment, 5 years, 1 year, 7 years, because there are different installment durations, in that in the businesses, right? So now the thing is, it is very difficult to imply some terms in this scenario. In such a case, the court can say that, the contract is held invalid, contract is void. Court can do that. Express terms generally override implied terms. Express terms are, I have more importance than the implied terms, obviously, because they are expressly agreed. However, the statutory terms can't be overridden by express agreement. Now, statutory means the terms by law. Obviously, if your terms are contradicting with the law, then your terms are not valid. Okay, then the law will be considered as superior. Like, for example, the law says that you have to give paid leave of 4 weeks to a person in 1 year. So if, let's say, you agree that I will only give you 1 week, let's say 1 week pay, 1 week paid leave for a year, then you are contradicting with the law. Then in that case, the implied term will have significance. But generally, the express terms override the implied terms. So you can say that express terms override the implied terms by custom, implied terms by law, by code, but not the statute. Okay. There are different types of term, condition, warranty, innominate terms. Okay, terms are basically the clauses, the essential clauses of the contract. Now the clauses are of three types: condition, warranty, and innominate terms. Now what is the condition? Condition is the most important term of the contract that takes you to the root of the contract. Warranty is a less important term that is incidental to the main purpose of the contract, while innominate terms are the term which is neither a condition nor a warranty. Now let's understand the condition and the warranty with the example. Okay, a very good example here. A soprano, Madam Bossard, agreed to sing in a series of the operas for Spires. She failed to appear on the opening night, and Spires refused her service for subsequent nights. Okay, so I will make this case easier for you. So there was a singer who did a contract with a person, Mr. A, that he will perform in his theater. No, she will do the singing in his theater. So singer did a contract with Mr. A, and the contract was to perform for 5 nights. Okay, singing for 5 nights. Now what happened was that the singer, she didn't came up on the opening night. She didn't came up on the opening night. She did a contract to perform for 5 nights, but the opening night she didn't came. And Mr. A, Spears in this case, he refused. He refused his services for subsequent nights as well. Okay. Now the thing is, here the court has to consider that the singer not coming on opening night, whether it is a condition or not. Now now this is a common sense thing, that if you hire some singer to perform on opening night, and that singer does not come on the opening night, so obviously the crowd there, the audience, they will not also visit the subsequent night as well, because it will give a bad impression, it will hurt the reputation, it will hurt the goodwill of the theater owner, right? So that is the condition. It was the most important term of the contract. So if the condition is breached, the remedy can be damages, discharge, or both. If someone breaches the condition, which is known as the important term, most important term of the contract, then the innocent party have the right. They can cancel the contract, they can terminate the contract, they can claim for the damages, and they can do both. They can they can either claim for the damages and let the singer perform the contract. Like for example, in this case, the theater owner can say that, you will pay me the damages which that you didn't come on the opening night. You will pay me the compensation for that, and you will perform the remaining contract. Okay, you can do that as well. You can cancel the contract as well. You will say that, I have terminated the contract with you. I don't need your services. Or you can do both as well. Cancel the contract and sue him for the compensation. If the term is a condition, if the term is the most important term of the contract. Now, warranty is the less important term that is incidental to the main purpose of the contract. Now, in the condition, the main purpose of the contract was to perform at 5 nights in the front of the audience, right? So the singer, she breached the condition. Okay. Now, warranty is less important term which is incidental to the purpose of the contract. Now, let's understand the warranty with an example. Again, there was a singer who agreed to sing in the concert, and the agreement was that, she will perform in a concert, plus she will do the rehearsal as well before appearing for the concert. Okay. Now, what happened was that the singer, she didn't came up for the rehearsals. The agreement was, the contract was that the contract was that the singer will she will come to the rehearsals as well, plus she will perform the concerts as well. Now the singer, she didn't come to the rehearsals. Now, not coming to the rehearsal is not a condition, right? The main purpose of the contract is to perform in the concerts, which is where the theater owners will get the earning from, right? That is the main purpose. The rehearsal, yes, it was a term of the contract, but it was the less important term. So you cannot cancel the contract just because she refused to come or she didn't come to the rehearsals. Okay. So that this breach is known as warranty. If warranty is breach, remedy available is damages only. So the theater owner, they cannot cancel the contract with the singer. Yes, they can sue him for the compensation. Why? Because that was a less important term. So warranty is a less important term. If someone breaches the warranty, then the solution is the damages only. You cannot consider the contract as terminated. Innominate terms. Innominate terms are the terms which you cannot determine, which is difficult to identify that, whether they are condition, whether they are warranty. So the terms which is neither a condition nor a warranty is known as innominate terms. Now, how to deal with that? Remedy depends upon breach. If trivial, treat it as warranty. If serious, treat it as condition. Very easy. If because of the breach of that innominate term, you are suffering serious damages, then that will be considered as condition. But if due to the breach of the innominate terms, the damage is not that much serious, then you will treat that term as warranty. So if it is treated as warranty, you can claim compensation from the other party. If it is treated as condition, you can cancel the contract. You can, claim the compensation, and you can do both as well. Okay. Now the next topic, and very important topic, is exclusion clause. Exclusion clause, also known as exemption clause, is the term that seeks to exclude or limit parties' liability for breach of the contract. Exclusion clause is known as exemption clause, and that these clauses are made as a part of the contract to remove yourself from liability. Like for example, if you go to a hospital, and you go to a hospital to get an operation, the hospital, they will sign an agreement with you in which they will mention that if something happens to you, we are not responsible. If something happens to you, we are not responsible. And you sign that agreement. This is known as exclusion clause, where the hospital are exempting their liability. Okay. Similarly, if you, let's say, you go to skydiving, if you go to for scuba diving, let's say any adventure sports, there they will sign a contract. Any adventure, there they will sign a contract in which they will mention, if anything happens to you, we are not responsible for that. That is known as exclusion clause. That is known as exemption clause. Okay. You go to a repair shop, you go to get your mobile phone repair. There in the shop, it will be notice will be mentioned that, if something happens to your mobile during the repair, if the mobile gets dead or gets damaged, we are not responsible for that. So this is known as exclusion clause, where you put up the clause, you make a clause, the part of the contract, to remove yourself from the liability, or to exempt yourself, exclude yourself from the liability. These are known as exclusion clause. There are the rules that you need to follow while setting out exclusion clause. So when you are setting out an exclusion clauses in the contract, you have to follow certain rules. The first one is the common law rules, and the second one are statutory rules. Now let's first understand the common law rules, and then we will talk about the statutory rules. Now, what does the common law rule states? In order to be valid exclusion clause, it must satisfy these two conditions. The first one is must be incorporated into the contract. The exclusion clause that you are setting out, it should be made part of the contract. It should be incorporated into the contract. That is known as incorporation control. Incorporated means that the other party must be aware that this is an exclusion clause. So how the other party will get aware about the exclusion clause? When it will be incorporated into the contract. And the second one is wordings must cover the loss. Interpretation control, that when you are setting out an exclusion clause, the wordings must cover the law, that if this happens, we are not responsible. The You should mention these things in clear words. It should not be vague. It should not be ambiguous. It should be clear that if this happens, if your mobile phones get dead, we are not responsible. You should not include some ambiguous or unclear exclusion clause. It will not be considered valid then. Okay, so in order to be valid exclusion clause, it must be incorporated into the contract, and the wordings must cover the loss. Now, how can you incorporate an exclusion clause into the contract? First one is by signature. Very simple. Like, for example, if someone goes to a hospital, they will give him a form in which they will mention that if this happens to you, we are not responsible. You will sign that document, right? So with the help of signature, now you have incorporated that exclusion clause, and the other party is aware about that exclusion clause, right? Incorporation purpose is that other party becomes aware that there is a certain exclusion clause there, and they should be aware of that. So by signature, clause is incorporated by signature, even if signatory did not read or understand the document. Yes, the law says that if someone signs a document in which exclusion clause is mentioned, that will be considered as valid, even if that person cannot read or understand the document. Okay, the law says that illiteracy is a misfortune, not a privilege. If someone is illiterate, it is not, you cannot present that as an excuse. Okay, so if someone signs a document in which an exclusion clause was incorporated, in which exclusion clause was mentioned, then with the help of the signature, we will assume that the exclusion clause is incorporated, and it will be stayed valid. Okay, if clause is vague, then it is considered invalid. If the wordings are unclear, if the wordings of the exclusion clause are ambiguous, then even if some person signs that, then still that clause will be considered as invalid, because we just studied in incorporation control, uh, interpretation control, that the wordings should be clear, right? So if the clause was in the contract, you signed the contract, but that clause was unclear, then it will be considered as invalid. The second way to incorporate an exclusion clause into the contract is by notice. By notice means that you should put a notice in your shop or anywhere where you're doing a contract, so the other parties must be aware of that this is an exclusion clause. Like, for example, if I go to a mobile phone shop and I want to get my mobile phone repaired, then that notice should be in that place where everyone can easily see that. Okay, like, for example, if I enter the shop, I can clearly see the notice in the front desk, on the front desk, where it is clearly mentioned that if you will not take your mobile phone within 7 days of the repair, we are not responsible for that. So that is, the notice is, I have the notice is brought forward to my attention, right? So this will considered as incorporated. But let's say if I enter the shop, the notice is not in front of me, it is, like, for example, it is in some backside, in some place else where it is not easy, where it cannot be easily seen, then that will be not considered as valid. Okay, so reasonable steps should be taken to bring exclusion clause to the attention of the other party. A clause can be incorporated by notice if it was given before making a contract. A very important point, that the notice should be given before an agreement or contract is done. Like, for example, when I entered the shop, in the notice, if the notice is in front of me, if I can clearly see that, and then I go to the shop, the mobile repairers, and I ask him to repair my phone, then it means the notice had been incorporated, because it has come to my attention, right? In regarding this, there is a case in the book in which a person went to the home, a person went to a hotel or restaurant, a person went to a hotel, and on the reception desk is a place where contract is made, right? He booked a room. And when he went to the room, inside the room, the notice was placed that if we are not responsible for your lost item. Okay, so now the contract was done at the reception desk, right? But the notice was given in the room, so that notice will be considered as invalid. That exclusion clause will be considered as invalid. Why? Because it should be provided, it should be bring forward to the attention before the contract is done. The third way of incorporation of the exclusion clause is by previous dealings. Okay, previous dealings mean that, let's say I am consistently dealing with someone and I am consistently notifying him about the exclusion clauses, and in a certain transaction I forgot to notify him about the exclusion clause, then still that exclusion clause will be considered as valid. Why? Because of our consistent course of the dealing, the other party knew that this is an exclusion clause, right? Because I already I notified him every previous time. So if on certain transaction I was not, I forgot to notify him, then we will consider that as exclusion clause to be incorporated. Why? Because of the previous dealings, because that party was previously dealing with us. But obviously the dealing should be consistent. Consistent means that, like, it's not like 3-4 times dealing, like 10 to 15 times dealing, like 4 to 5 years we are dealing. So in such cases we will consider that exclusion clause to be incorporated. Okay, the third point simply means that if you are doing business with someone and on all of the previous occasions you are notifying them about the exclusion clauses, in the contract, in an agreement, and on a certain transaction you forgot to notify them, still, that will be considered as valid, that will be considered as incorporated. Why? Because of the previous consistent course of dealings. So the first in the common law rules, the first condition was that the exclusion clause must be incorporated into the contract. And how can you incorporate that? By signature, by notice, and by previous dealings. And the wordings must cover the loss. Wordings must cover the loss means that the exclusion clause of the wordings should be clear, that if this will happen, we are not responsible. The wording should be very much clear. Okay, the wording should be very much clear. Now there are two rules in the interpretation control. The first one is contra profantem rule. Under contra profantem rule, court interprets the word narrowly against the interest of the person seeking to rely on the clause. The court says that, the party who is trying to exclude themselves from the liability, the court said that, it was their responsibility to mention the exclusion clause in clear words. But if they will not do that, if they will use unclear words, if they will use vague words, if they will use ambiguous words, we will interpret the clause against them. Why? Because it was their responsibility to put forward a clear clause, put forward a clear exemption clause. Okay. So if the exemption clause is vague, if it is ambiguous, if it is unclear, then it can be considered as invalid, and the court will interpret that. If court will go towards the interpretation of that clause, they will interpret against the interest of the person who was trying to exclude themselves from the liability. And an exclusion clause that affects main objective of the contract will not be enforceable. That is known as main purposive rule. What does this mean? That if you are putting an exclusion clause which says that, that if which is affecting the main purpose of the contract, that will be considered as invalid. Like, for example, if someone purchases the lectures from me, okay, I am teaching the law. Okay, if someone purchases lectures from me, and he says that, I want to purchase your lectures, I want to study from you, and when and I in the agreement, I will mention a clause that, I will not teach you. If I will not teach you, I will not be liable. If I will not teach you, I will be not liable. So this is now affecting the main purpose of the contract, right? Objective of the contract. The objective of the contract is that you are going to study with me, right? You want to get tuition from me. So if I am, mentioning a clause that, let's say, if I am not able to attend your, if I am not able to teach you, I will not be liable. I cannot do that. I cannot use such exclusion clauses. They will be considered as void. They will be considered as invalid. Okay. So these were the common law rules. The common law rules, there are two conditions that need to be satisfied. Number one is exclusion clause must be incorporated into the contract. Number two is the wordings must cover the loss. How can you do the incorporation? By the signature, by notice, previous dealings. Signature means you are signing the document yourself in which the exclusion clause is mentioned. Notice means that you are notifying someone about the exclusion clauses, and the notice should be, reasonable steps should be taken to bring exclusion clause to the attention of the other party. Like, for example, notice boards, for example, tickets. Like, for example, when you purchase a railway tickets, airline tickets, on the back of the tickets it is mentioned that, if this happens, we are not responsible. So, putting those on the back of the ticket is a reasonable way to bring the clauses to the attention of the other party, right? So we will consider them as valid. And then the previous dealings. The second condition is that the wordings must be plain and it should cover the loss. And if you are not doing that, then, the court will interpret the clause against those parties who are trying to rely on the clause. And any exclusion clause which is affecting the main objective of the contract, it is not enforceable. It is considered as invalid. Then comes the statutory rules. If the exclusion clause passes the common law rules, then we will apply statutory rules on that. Okay. And if the exclusion clause clause passes statutory rules, then it will be considered as valid. Okay, so the exclusion clause, to be considered as valid, it should pass both the common law test and it should pass the statutory rules as well. Now, what are the statutory rules? There are two statutory rules: Unfair Contract Terms Act UCTA 1977 and Consumer Rights Act CRA 2015. Now let's first discuss the UCTA 1977. Now, Unfair Contract Term Act, it applies to the exclusion clause in business to business contracts. Okay, so if the contract is done between business to business, this applies there. Okay, now what does the Unfair Contract Terms Act 1977 says? It states that the clause excluding liability for death or personal injury due to negligence is void. Unfair Contract Terms Act 1977 states that if a party has put up an exclusion clause in which they have mentioned that if due to our mistake someone dies or someone suffers personal injury, we are not responsible. Such a clause is void, invalid. If you are excluding the liability for death or personal negligence due to your mistake, then the court will say, it is a statutory rule. It means the law, parliament has derived that. Then in that case, the law will say that, it is invalid. You cannot make any exclusion clause through which you are excluding yourself from the liability of death or personal injury due to your mistake. Your mistake. Like, for example, if the doctor says that anything happens, we are not responsible. Okay, even if even because of our error you die, we are not responsible. Even because of our mistake you die or you suffer injury, we are not responsible. So that will be considered as invalid. Okay, that will not be considered as reasonable. That will be invalid. In sales contract, excluding right to sell of the seller is void. In a sales contract, you did a sales contract with someone, like, for example, you did a contract with a supplier and you ask him to supply the goods to you, and you put a clause excluding him, that saying him that you cannot supply good to someone else, or you will only supply the goods to us, even if we don't agree to get, if even we refuse to get goods from you, but you are only bound to supply the goods to us. So you are excluding the right to sell of seller. Such an exclusion clause will also be considered as invalid. Okay, these two exclusion clause will be considered as invalid. For the other exclusion clauses, you have to assess reasonableness. You have to assess reasonableness, whether those clauses are justifiable or not. If they are justifiable, then you will consider those clauses as reasonable. Like, for example, I gave you an example that if the doctor says anything happens, if anything happens because of our mistake, you we are not liable for that. Okay, so that is invalid, right? But if the doctor says that we will try our best, but if still something happens, we are not liable, then this can be considered as justifiable, right? But if they clearly say that because of our negligence, if we do an error and because of our negligence the other person dies, we are not responsible, that is invalid. Okay, so you have to assess the reasonableness. Okay, reasonableness, while assessing the reasonableness, you have to consider these four factors. The first one is strength of bargaining position of the parties. Bargaining position means how strong one party is. Now if a party is in a stronger position than the other party, then he can put up the unfair clause, right as well. So the court will see that if one party's bargaining position is stronger, then maybe that party is putting up the unfair clauses, and the other party have to approve that. Okay, so court will consider that. Like, for example, if a patient is in emergency and if he goes to the hospital, and the hospital says that if this happens we are not liable, if this happens we are not liable, if this happens we are not liable, he will say that you know just give me the document, I have to sign that, so you can treat me, you can operate me, because he's in such position, he is in position of the he's on the deathbed, right? So in that case, the the hospital can the hospital's bargaining position is high because the hospital is a stronger party, so they can put up unfair clause, right? So the court will assess this point as well, that whether the stronger party has put up the unfair clause or not. Maybe the stronger party haven't put up the unfair clause, but this is a factor that we need to consider in order to assess the reasonableness. Whether there was an inducement given, whether there was some benefit given to you. Like, for example, uh, you let's say you purchase some clothes. Okay, you purchase some clothes and you were given 40% discount on that. You purchase some clothes, the price of the clothes was $1,000, let's say, for example, and you were given 40% discount on that, and against that discount there was an exclusion clause that was signed, that if something happens to these clothes, we are not liable to pay you, or we are not liable to refund you. So the you are given the benefit of the discount, you are given the benefit, and against that discount the exclusion clause is signed by you. Okay, so you are given inducement. In such a case, the in the court will assume that this exclusion clause is valid. Why? Because you are getting benefit as well. So if you are getting benefit, then the court will say that, okay, maybe that was not so much reasonable, but still you get some benefit against that. So it will be considered as valid. Okay. Ability of the party to provide compensation. The court will look at the ability of the party to provide compensation. Like for example, if due to the negligence of, let's say for example, the hospital says that if due to if let's say for example you went for the skydiving, let's say for example, or if you went for the swimming school, or if you went for any adventure sports, or let's say you went to a cricket ground, and there there was an exclusion clause mentioned, that if the ball is, let's say, if you got hit by the ball, we are not responsible, or if you got hit by the ball, we will pay you this much amount of compensation. Okay, now the thing is, let's say if someone is hit by the ball and he suffered serious consequences, serious damages, and the amount of the compensation is too much high, and the stadium owners, they have the ability to provide the compensation, then they are not limited to provide the minimal amount of the compensation. The clause that they put up, that if damage happens to you, we will compensate you for 100 pounds, let's say, or $100, and now the let's say expenses are of $800. So if those are response, if the stadium owners can pay $800 for the expenses of that person who got injured, they have to pay that. Okay, there is then the clause of $100, that will be considered as unreasonable, unjustifiable. Why? Because they have the ability to compensate the other party. So if they have to pay him. Okay, whether the party knew about the extent of the term or not. So that is also important, that the party who is uh, signing the contract, whether they were aware that this exclusion clause was put up there. If they were aware, then the clause will be considered as reasonable. If they were not aware, that then the clause will be considered as unreasonable. Why? Because obviously, you can how will you bring that to attention of them? By signature, by notices, and by previous dealings. If you are not, if they do not know about that term, then that will be considered as unreasonable. Okay. The other act is Consumer Right Act 2015, and it applies to the business to consumer contracts. Okay, consumer. If let's say I am going to purchase a mobile phone, I am a consumer, and the shop from which I am getting the mobile phone, let's say I'm getting Apple phone, Samsung phone, those are the business. So the Consumer Right Act 2015 deals with the consumer rights. Okay, it also deals with the exclusion clause regarding the business to consumer contracts. Plus, it also deals to save the consumer rights. Okay, to uh, to put the consumers in the security. Okay, this is the purpose of the Consumer Act 2015. Now what does the Consumer Rights Act 2015 says? Clause that exclude liability for personal injury and death due to negligence is void. Again, the same clause, that a business cannot put up an exclusion clause into the contract and say that if because of our negligence the consumer dies, we are not responsible. They cannot do that. Like for example, the manufacturers, let's say there was a manufacturer who is manufacturing the drinks, soft drinks, and let's say one soft drink was poisoned. The certain person, he go to the shop, he drank that, and he got he died. Now they cannot say that, because of our negligence he dies and we are not responsible. That is invalid. Okay, that is invalid. Clause that exclude consumer right is void. If you are excluding the consumer rights, you are taking the rights away from the customers, consumers, and by putting a clause, that clause is also considered as invalid. Okay, so these two clauses are automatically invalid. Number one, excluding liability for personal injury and death. And the second is excluding the consumer rights. They will be invalid. Other clauses will be considered as fair if they are expressed in plain languages, or if it causes imbalance in parties' right. Okay. If it does not causes, I think. If it causes, okay. If it causes imbalance in the parties' right. So other clauses, they will be considered fair, except for the first two options. The other clauses, they will be considered as valid, they will be considered as fair if they are expressed in the plain languages. Okay. So other clauses are considered fair if they are expressed in plain languages, or if it don't causes imbalance in parties' right. So these two clauses, they will be considered, the first two, they will be considered as invalid in all situations, automatically unenforceable. But the third one, except for these two, all the clauses will be considered fair if they are created, if they are included in a good intent. And what is good intent? That you have expressed those clauses in plain and easily understandable languages, and they are not causing imbalance in the parties' right. Now, what does the imbalance mean? Like, for example, a business is in a stronger position, a consumer is in a weaker position, right? Now, the business cannot force an exclusion clause onto the consumers that are unfair. In that case, they will be considered as invalid. Okay. Now, the summary is, if you want to set out a valid exclusion clause, first you have to see whether that exclusion clause passes the common law test or not. Okay. What is the common law test? Whether it is incorporated, you can incorporate it by the signature, by the notice, and by previous dealings. Whether the wordings cover the loss or not, the wording should be clear. It should not be ambiguous. It should not be ambiguous. It should not affect the main purpose. If no, if the common law test is not passed, the clause will be invalid. If it is passed, then you will see the statutory rules. If it is business to business contract, you will see UCTA. If it is business to consumer contract, you will see CRA. For UCTA, obviously we have told that if you are setting a clause in which you are exempting the liability for death or personal injury due to your negligence, then it will be invalid. And the other clauses, if they are reasonable, they can be considered as valid. Similarly, for CRA 2015, if you are creating a clause in which you are excluding yourself, exempting yourself from the liability for the death or the personal injury due to your negligence, then it will be invalid. Or you are affecting the consumer rights, you are taking away the consumer right, that is also invalid. And the other clauses, if they are mentioned in the plain languages and if they are not causing an imbalance in the parties' right, they will be considered as valid. Okay.